Hello everyone, my name is Shelton Williams Jr., and my goal is to own my own hip-hop record label and transform that record label into an entertainment company. In order to increase my knowledge on the legal aspect of the entertainment industry, I watched a legal podcast and followed up by doing research on the topics I was unfamiliar with pertaining to entertainment law. In order to increase my knowledge on the legal aspect of the entertainment industry, I watched the 53rd episode of Entertainment Law Update. The show was hosted by Gordon Firemart and Tamara Bennett. During the show, Firemart and Bennett discussed multiple cases of trademark. They also discussed George Clinton and his copyright case. Firemart and Bennett discussed many topics pertaining to the entertainment industry. However, I found that these cases involving copyright and trademark will help me as I start my own record label. The first case involving trademarks dealt with the Washington Redskins and their trademarks versus 5 Native Americans. I found this case interesting because the term disparaging was mentioned. I was unfamiliar with the term disparaging and the effect it could have on trademark registration. When the TTAB rejects or cancels a trademark because disparaging, it means that the trademark is considered offensive to a group of people, institution, or a national symbol, according to Bill Donahue. The TTAB canceled the Washington Redskins trademark June 18th after 5 Native Americans claimed that the trademark was disparaging to Native Americans. My initial thought was that a trademark had to cause a likelihood of confusion or violate the federal anti-delusion laws to receive rejection or cancellation from the TTAB. However, offensive marks can also cause the TTAB to cancel or reject a registration for a trademark. The second case involving disparaging involved the Discovery Channel series Amish Mafia. The trademark office denied the Discovery Channel trademark rights for Amish Mafia, stating that the title was disparaging to the Amish community. According to Firemart and Bennett, the TTAB says the violence associated with the mafia paints a bad image to the Amish community. Firemart and Bennett also emphasized that a canceled trademark registration or a rejection does not mean a company can't use the mark. It just means that the mark is not registerable, and this can cause the company many financial troubles when trying to protect the mark from secondary people who want to capitalize off the mark. It is also interesting to note that a title for a single work is not registerable. However, in a series of work, a title can be registered as a trademark. Firemart and Bennett also explained how subjective the TTAB can be. When filing a mark, the two explained, a company might have to educate the examiner about the industry the mark will be used in, and use examples of other marks that might be considered disparaging to push the trademark. The next topic I found interesting on the podcast was involving George Clinton. Over the last decade, George Clinton has been in numerous copyright lawsuits over his past work. These lawsuits have created a large bill with his attorneys. Clinton believed that the law office of Hendrick and Lewis denied him rights to use his copyright material. The law office has been able to put Clinton masters up for sale in order to pay his debt. There has been an arbitration awarded to the firm against Clinton, giving the firm secure interest in his copyrights. Clinton appealed this ruling based on copyright laws that states authors are protected from involuntarily transferring copyrights. What makes this case interesting was the fact that Clinton made an agreement with Warner Brothers back in the 70s, which made him an employee and his works were a work for hire. Clinton argued that a sound recording cannot be a work for hire. However, the Ninth Circuit Court of Appeals states that even if a master is not a work for hire, protection does not apply when a copyright was previously transferred voluntarily by the original author, referring to Clinton's dealing with Warner Brothers, according to Eric Garner on Billboard.com. My key takeaway from this case is that a work for hire is considered a voluntary transfer of copyrights from the original owner, and the original owner loses certain protections under the copyright laws. This was my first time watching a legal podcast, and I found it very interesting. I realized when registering a trademark there are many factors to consider, and the process does not stop after filing necessary papers. I also learned when dealing with copyright, an author can lose protection depending on how the papers are filed. I also realized that copyrights are an asset, and as an asset, they can be used as payments for debts. Thank you everybody for listening.